probate process. So largely we're going to be talking about, identifying what is probate, what goes through probate, and the kind of family dynamics that can happen within that probate. If you're joining us live, if you're registered for the event, there is a Q&A, so question and answer feature available. I do have those question and answer pulled up here on my screen, so I should be able to see if anyone asks any questions. You don't need to wait to ask questions until the end. If I'm talking about something, you have questions, that's great, because maybe other people have those same questions. So if you feel comfortable putting those into the Q&A feature, I'm happy to answer that live. If you're watching a recording of this webinar, just know that if you attend live, you're able to ask those questions right as we go with our topics. So our material for today is going to be all about, again, a probate versus non-probate. We're going to have a handout that's emailed to everyone who's a registered attendee for the webinar today. So that'll be sent out to everyone along with like a feedback or survey form. So just so you're aware, with Hooper Law Office, we do offer complimentary initial consultations. We schedule those for 2 hours where you get to meet with an attorney from our office. That way we can, get to know you specifically, your goals, maybe your questions. Typically by the end of that 2 hours, we're able to make a recommendation for what you should do, quote any fees there, but as I said, it is complimentary. So if you'd like to at all get that scheduled, there's a way to do that right in that feedback form as well. So just know that we offer those if you have any specific questions that either you don't want to answer here or that you need kind of more time to work through. Okay. So jumping right into probate a little, I just wanted to start off with, what is probate and probably just some bigger myths with that. So probate is a court process that someone can go through if they don't have a will. So for example, if you just pass away, you don't have any estate plan, you don't have any designations on your accounts, you can go through probate. But you also go through probate if you have a will or if you don't have like beneficiary designations on things. And if you want to use your will, you actually want to use probate. So probate can sound kind of scary because maybe people are familiar with it, helping a previous family member, or you've seen it online or in TV shows. And the probate process is a court process that helps to settle up someone's affairs or their estate, which is just whatever you own when you pass. So that way it gets to the people that they had wanted it to go. So it is a public court process. So a lot of times, just making you aware that whether you pass without a will, which is called intestate, or if you want to use your will and have, assets directed through your will, you want to use probate. So wills don't avoid probate. They're kind of just a set of directions to the probate court. So there's a judge. Typically what happens with probate is that when someone passes away, the family will admit their will, which again is that set of directions, to the register in probate. They get a case number. There's a nominated personal representative, or also called an executor. Typically, about 30 days after that, they get that approval. They get issued their domiciliary letters, and then it's just that's that process until it concludes. So why does probate take so long? Why are people sometimes trying to avoid it? And probate is a really important process. It helps to make sure that whatever you have in your will is followed, that it kind of has that result that you were intending. So probate can typically take about a year to a year and a half to complete, and that's just kind of start to finish. The reason why it takes that long is not because your personal representative, or also called your executor, is not doing their job. It's because there's this idea of court set timelines or deadlines that someone has to comply with. So there's state law, that walks through, well, how long do you have to give notice to creditors, and what's that final, deadline, and who do we have to tell about these things? So what's important is in probate is that, there are notice and service requirements. So even if your personal representative is pretty speedy, they're doing a good job, they're doing what the court says to do, your timeline is still pretty typically, that that person will pass away. Their family has like 30 days to go and file their will with the probate court. Once the will has been filed, that will includes like a nomination for a personal representative, or also called executor. That's the person who's going to go ahead and make sure that decedent, which is the person who passed, that all their bills and final expenses are paid, and then things go out according to their wishes. So they submit all the documentation to court asking to be personal representative. They answer some questions about themselves. They get hopefully approved by the court. So most of the time, unless your personal representative is passed away or incapacitated, which is why you have successors, that person normally is approved by the court, whoever you nominated, unless maybe the court has some concerns. They're typically approved 30 days after the point that the will was filed. It's not that that can't be faster, it's that there's notice and services that are going out to all the interested parties. So who is an interested party in probate? That can be the people who are actually receiving. So if your will says, I pass away and I have 3 kids and I'm just leaving everything to my 3 kids. Well, that's pretty easy because A, they're your beneficiaries, they're who you're leaving stuff to, but they're also your heirs at law. So sometimes where people can get concerned is the fact that all these notices are going out not only to the people you're actually leaving stuff to, but people who would have otherwise received from you, either in a previous will or because they're an heir at law. So in that 3-child example, if, and people disinherit kids or anyone for any number of reasons. But if one of those children are disinherited, they still have to receive information that this probate action has been filed. It's not saying that now you're getting a third or anything. If that child is disinherited and, the judge doesn't see any issues with that will, which I'll explain more, I promise, then that 3rd child, that one who's disinherited, is still subject to, here's this probate action, and this is who's saying they want to be personal representative, and do you have any problems with this? Because everyone has the option to kind of contest that personal representative. If they are, someone who's receiving, if they're someone who should be receiving, because all of this is now public. So all of your beneficiaries and heirs at law are entitled to receive copies of these documents, copies of the will, and they can just kind of read the whole thing. So even if you have specific information that, I'm not leaving this person a residuary interest and not, hey, whatever's left, I'm leaving them $500 or $1,000 because they're my best friend or they took care of me, it doesn't matter. They still get to know kind of everything that's going on in the will. So the will itself is then entirely kind of public to the interested parties and heirs. It also is just in general, probate's a public court process. So there are some information that someone even outside of your family can access. So I don't know if you've ever CCAP'd anyone, if you're nosy or just, because you're pretty familiar. CCAP is where you can go on and see, like, has anyone ever been sued or had a criminal action or, filed for a divorce? Have they also ever been a beneficiary of a probate, or have they had a probate? Because it lists all those, again, those interested parties on those records. You can figure out information about, like, what was the inventory value, some of those things. So just know that your will itself is inherently more public to the people that are receiving, and probate in general is public. Now, where it can be a problem with interested parties is, like I said, people disinherit kids for any reason that they want to. Your kids don't have to receive anything from you unless they're minors. You don't have to leave things to your kids. Some people end up deciding to, say skip a level, leave it to their grandkids. Or sometimes people will say, equal's not always equitable. I have that 3-kid example, but I have one child that I supported a lot during my lifetime, and I'd actually like to reduce what they're receiving from me now and give more to the other kids. you can do whatever you want largely with these things, but you have to be aware of the information then that the family is getting and how that can impact their dynamics. Because I always would encourage, while estate planning is still private, that you have good conversations with your family about, I have these documents, or this is what I'm hoping to do, just so that way if you do disinherit someone or have different reasoning, you have the chance to explain it where they can ask you questions. And you can discuss it rather than just one sibling who's the personal representative being like, actually you're receiving less, and you don't have a chance to explain yourself, because it doesn't really explain, it just shows what you're receiving. So again, everyone kind of receives those notices if someone actually contests something. So just because someone is disinherited doesn't mean that they're going to contest. Just because someone is receiving something doesn't mean that they are also not going to contest. If someone contests anything about the will, they try to say that it's invalid because of undue influence or capacity concerns, or they think that that's not the most dated version. It doesn't really matter. If anyone contests it, that year to a year and a half, all bets are just kind of off at that point. Probates can take years if they're potentially contested. So any questions just on the fact of how information is working with beneficiaries, how people can, and heirs at law, how they are entitled to that information, they can see it in general, how probate is public. Okay, so I'm not seeing any questions right now, and that's totally okay. I just want to make sure that if anyone has them, that I'm answering as we go. So with that privacy component, once we kind of move past the personal representative and getting them approved, there are still other court deadlines that your personal representative has to follow. So really common thing, notice to creditors. If you've ever seen in newspapers, it says something like, the estate of so-and-so, if you have a creditor claim, you have, until this date to file it, and this is the court number, and this is the county. The reason that those things are put out is because in probate you have to. So the personal representative is always going to have to firmly tell the creditors that they do know. So like if they know that there's a hospital bill, they got to send something specific to the hospital. If they know there's, all your creditors will get paid, but there's also in general just that open notice of, hey, if you have a claim against this estate, your credit card company or some other creditor, you have until this date to come forward. And then after that, you can't really make a claim. The reason why that's so important is because it gives it almost like a drop dead date, if you've heard that. This is the latest that creditors can file. Now, creditors can come forward. They can come forward, submit their claim. The court will approve, if they get paid or who gets paid and all those other good things. If those creditors miss those dates, your personal representative doesn't have to pay them. That's a really nice part about probate, right? We have this set process. We know what's going to happen. We know that your personal representative gets approved. They take that inventory. They send out these notices. They finalize everything. They liquidate whatever needs to be liquidated. They have a final accounting. Everything goes out. Yes, it takes time, but it can be really helpful to guarantee the result and have that process. One of the biggest things your will is trying to do is settle your affairs, your personal affairs, before anything else goes out. And where that is bills. So whether or not you have major creditors, you don't have to have what's called a deficit estate. So like a deficit estate is where someone might just owe more money than they have. So it's kind of like their estate filing bankruptcy. Super important to use probate if you have that, because we want to make sure that even if no money's go out to your family, we'll neither do your liabilities. So that is important if you have a deficit estate, but for most people, there's always some level of creditors, right? Even if you're really good and pay your credit cards on time, you typically have that last month's statement, or you might have whatever expenses for your funeral or burial, or you might have your hospital bill, or your utilities on your house until it sells. All these things are bills that need to be paid to settle what you have first. And probate is excellent at that, because it's taking everything together, making sure creditors are paid, bills are paid, and then everything else is going out. The problem is when we start to talk about avoiding probate and avoiding it without otherwise having like a good coordinated plan. Because sometimes people hear negative things about probate, and they hear that because of the year to a year and a half, the largely attorney's fees and other fees associated with probate, and the fact that it's that privacy concern. So sometimes people are nervous to use probate, so they try to avoid it, and they're avoiding it with things that don't use probate. So for example, if you have pay on death or transfer on death or beneficiary designations on accounts, those things never actually get to probate to begin with. So yes, they avoid probate. They don't need to use the court process. What happens with those type of things, like say someone has a TOD deed, a time of death designation on their house that says my house is mine, but when I die, it just goes to these people, or my bank account is mine, but when I die, it goes to these people as a pay on death. Those people then submit your death certificate to that institution or to the Register of Deeds, and then whoever it's designated to, it just transfers out to them. So it's that point A to point B transfer process. I use beneficiary designations all the time. They are so important. They are such helpful tools, but you need to understand that they don't by themselves have that same process and planning techniques that are important to make sure that your creditors are settled with and your bills are paid. Because exactly like I'm talking about, someone will submit a death certificate and then those assets go out. They never have that same opportunity to come together. So where this can be hard for families is, well, now how are we supposed to pay creditors? How are we supposed to, make sure that we have that set dates, that way we're not worried about someone coming back after we've already spent the money? How do we make sure mom or dad's funeral and utilities, how do we work on all these things? And in probate, that's already set. You see, there's that court, those deadlines. It has the process. Yes, it takes time. It's not a bad thing. It's not a bad thing. It's just that with beneficiary designations alone, without having at least some things kind of use probate, people can run into problems. Let's just take bill pay. Let's focus just on that. You have the 3 kids. Everything is beneficiary designated or transfer on death or POD, all those things. And it goes right out to the 3 kids. Now, those 3 kids, after they've already gotten their money, they've gotten their equal thirds. Now they have to say, okay, well, let's pull everything back or figure out what mom and dad had, and then we'll total that up and then we'll split it by 3, and then everyone is responsible for these things, except that there's no actual obligation to do any of that because it's just now the property of these 3 people. It was not firstly used to make sure everything was settled and then went out. And you can have really great kids. You can have really great kids now. But it just becomes a problem because I think that there's still even just a mental difference between, okay, everything came together, bills, final expenses are paid, and then everything goes out. Versus if you make sure that everything goes out and then bills and stuff are paid and then everyone shares, you can run into problems where someone doesn't share. And whether that's just because they don't want to, because again, no legal obligation to do that. If they decide that they don't want to, that can create problems. If someone wants to, they want to settle up with their siblings or other beneficiaries, but they can't. There are, in that case, when they're trying to get the money together to pay mom or dad's expenses, there are legal reasons why someone can't reimburse or pay their siblings, is because that's now considered a gift. When it goes out through the probate process, your personal representative, it's not theirs. They're kind of like your manager, right? They're just making sure that they're following what the court says and getting things where they need to go. Versus if everyone owns those things now, well, whatever happens to an owner happens to that thing. And since there are no legal obligations, because you didn't have the probate, if that child is getting divorced or they're being sued or they need to file for bankruptcy or they're disabled and on supplemental needs or receiving care and now need to be worried about Medicaid, that can mean that they legally cannot return those funds to the other siblings, even though they might choose to. So that's where families can end up having, unfortunately, a good degree of conflict. It can be confusing about settling all those things. Maybe your most responsible child goes ahead and makes sure that that's settled. And then ultimately they receive less than their siblings because they did that. They receive less from you because they did all that work. So that's not really what you want. You want to have the set result that probate gets you, and that's why it's so helpful. On the opposite end of bill paying, sometimes I have where people will, like, instead of sending it out into the equal thirds, they just put one person on everything. So instead of having, the thirds go out right away, they pay it all to one person with the intent that that person is like a pseudo personal representative. They're going to make sure that everything comes together. They're going to pay bills, final expenses, and then they're going to split it. And you still run into the same problem of not having an obligation to do that. It's just theirs. They don't feel like sharing. They don't have to share because it didn't use the probate process. It went through these other tools. Excellent tools, not by themselves a plan. So what you want to make sure is that you're using potentially probate and other things and have everything coordinated. Why probate can always be so helpful, again, is that process. But I often tell families too, if you know that your family is going to fight no matter what you do, probate is also not a bad place to be, because that judge is kind of like that arbitrator. They're deciding, okay, this is what we're doing, this is what the will says, and now we're going to move on. And then at the end of the day, it's going to be settled. It's going to be settled. It gets that result. Might take a little bit of time. If you have an attorney, it could certainly cost. Probate's not inexpensive. But if your goal is to try to keep your family together, not have anything where, okay, accidentally someone got more or less or nothing, it's that result that's so important, because otherwise, you hear stories about families where they end up not talking to each other after their parents pass because they had all these issues come up when mom or dad passed. They didn't resolve it correctly. They didn't have that plan in place, and now no one speaks. And that can be really hard, just trying to, maintain that harmony and get rid of that conflict. Just don't be afraid of probate. Know when to use it appropriately. And when people are talking about, okay, well, I like the process that probate has. I like that it guarantees the result. I like all the positive things that it does. I just don't like the time, the expense, the public nature of it. That can be important. That's a trust. So kind of very simplified version of trust. There's literally hundreds. They do all sorts of different things. But trusts have a private administration, so they still follow a lot of the same process that probate does. It's just that they don't require a judge. It's all administered privately by your trustee. And you can even put some additional privacy protections in there where you can say that, no one is to receive any information about this trust except for the people that it pertains to. So if you do have a child that you're disinheriting, well, then you don't have to tell them anything. They don't have any information, so that can help to limit contests. But also, if you decide to do something maybe not equal to your kids, or it's just what you want to do that you think maybe they won't understand or they won't like, you want to leave a specific amount to grandkids right away. I see that a lot. You can still keep privacy between beneficiaries in a trust. So, for example, you can say beneficiaries receive the information that pertains to them. So I'm sure your kids are smart enough, if there's 3 of them, I would hope so, where you can say, okay, everyone receives the information that pertains to them. So if they're receiving an overall percentage, they get to know this is how much there was. These are bills and final expenses. You received a third, that's that third. So that way they can check the math. So if they know they're one of 3 siblings, they're going to be able to figure out, okay, I received an equal third. But if they're one of 3 siblings and they receive 20%, they don't actually know for sure what everyone else received. And your other kids don't have to share that if they choose not to. The only person who's really going to know everything is yourself and your trustee. So you want to be picking good trustees. You want to have people that are going to, follow your wishes and, get everything taken care of. They're just kind of like that personal representative role. They have duties and obligations to your beneficiaries, but they don't need a court to go and tell them, following these process largely, they are able to do that. And then in that way, they're much faster typically than a court. So that's why you'll see like trust administrations 6 to 8 months, kind of on the average end. I've seen them be quicker. Settling less than 4 months is pretty rare, but it happens. It really is the speed of your trustee. So good caveat to this, pick a good trustee, pick a reliable person, so that way if you don't want to have the court involvement and you still have that process, that you have a good and responsive person as that trustee. There are professional trustees. So just so you know, if you don't have anyone, but you don't want to use probate, there are those professional options. So I know I've covered a lot pretty fast today. This is a big topic, certainly. So I wanted to make sure to cover what I thought people would really have questions on. Again, if you have any questions, I have just a couple of minutes left before we're kind of set to conclude. So I'm happy to talk about anything you have questions for. Otherwise, I guess I'll just kind of plug next week. We're actually going to be talking about at our webinar next week, estate planning for blended families. So if you have a second or third marriage, or you have children from a previous relationship and now you're married, and that's a blended family, we're going to be talking about specifically some estate planning concerns and things to be aware of for that. February 14th, we're going to be talking all about Medicaid, understanding Medicaid eligibility. So I know last week I did a class on our webinar on Medicaid in the home. Now we're going to be talking more about Medicaid eligibility. So that's a good one if you have long-term care questions. Otherwise, on the 21st, we have our big wills and trust seminar. So what that is we go into more detail on wills and trust, powers of attorney, a little bit on long-term care planning. It's a really good foundation. If you're kind of new to estate planning or wanting to understand some key concepts, that's really helpful. We run 2 sessions of those, and we rotate between Appleton, Green Bay, and Oshkosh. So our next one on the 21st is at the Neville Public Museum in Green Bay, and we have a 2 o'clock and a 6 o'clock. And for all of these events, you can see our whole list and register for them. Go to estateplanninglive.com. and you should be able to see and register for that. Otherwise, know that materials for today, this like probate, set of probate that I've been referencing is going to be emailed to anyone who's registered. And if you'd like to reach out for those 2-hour initial consultations, you can do so right on that feedback form. Otherwise, I will go ahead and let everyone go. Thank you so much for your time.